has now been outlawed. For corporal punishment requires the infliction of maybe cane to beat an offender, which ordinarily will constitute assault. As by law, it is justified. We also have examples of justified or excused assaults, which we see on daily basis. For example, when two or more people are meeting in a narrow place, there is bound to be bodily contact. When there's a state of stampede to save life in an emergency situation, there is bound bodily contact. Then when there's a rushing to catch a bus in bus stops like Yaba bus stop, especially in metropolitan city like Lagos, or when you are in a barbing salon or a hairdressing salon, the barber can just slap your head under the guise of being your head. And of course, you can't maintain an action for that. Then also in footballing or boxing or other sports that require bodily contact, in justified instances in which assaults, may be lawful. But in this case, before you can talk about assault, it must be unlawful. So then, after all these 5 requirements, there is the 6th requirement. And that 6th requirement, as it relates to the offense of indecent assault, is the indecency of the act. The indecency of the act. And what do we mean by indecency of the assault? It is believed that the act is usually targeted at the private parts, like touching a woman's breast, pubic hair, pubic area, or buttocks. What makes it indecent is the part of the body, that the assault is targeted at. Don't forget that we are talking specifically about indecent assault on females, because we have different types of indecent assaults. But we are concentrating on indecent assault on females now. So the part of the body determines whether that assault is assault simpliciter or indecent assault. So if it is targeted at the woman's breast, pubic area, or buttocks, these are parts of the body that can make the assault to constitute an indecent assault. So we also have marital exception here. There is no way an assault occasioned to a wife by a husband can amount to indecent assault. And on that, you see the case of Alawusa versus Odusote. Alawusa is spelled A-L-A-W-U-S-A. Then Odusote is O-D-U-S-O-T-E. 1941, 7 Waka at 140. Alawusa versus Odusote is 1941, 7 Waka at 140. Yes?
Sorry, sir. Can you come again with the point you just made about husband and wife?
I said there is marital exception under indecent assault, that it is not possible for an assault committed by husband on his wife when they are married. There's no way it will constitute indecent assault. It can only amount to assault simpliciter. Okay? In Odusote, in Alawusa versus Odusote, of which I've given you the citation, the accused shaved the complainant's pubic hair, that is the pubic hair of his wife, without her consent, and was charged with indecent assault. But the court held between them could not be indecent simply because they were husband and wife. So the court convicted him for assault under section 351 of Criminal Code. The court convicted him for assault under section 351 of Criminal Code, which is only punishable with 1 year imprisonment. Which is only punishable with 1 year imprisonment. So you can understand the essence of this case. The purport of this case is the exemption between husband and wife when it comes to indecent assault. So there can't be indecent assault between husband and wife, but amount to assault. Okay, so section, yes.
Is assault
Yes.
simpliciter, is it actionable?
Yes, why not? That's why I said the assault in this case now was punishable with 1 year imprisonment. The husband was actually sentenced.
So can you
Are you
explain what?
following me?
Yes. Can you explain what assault simpliciter means?
Assault simpliciter means ordinary assault. You know, we are treating indecent assault.
Yes, sir.
Are you following me now? We are treating
Yes, sir.
indecent assault.
Okay.
Ordinary assault, and I'm talking about in the context of ordinary assault.
Okay.
You see, you can also have occasionally harm or assault occasionally grievous bodily injury. And those ones are more grievous. They are all species of assault. But the assault in this case was just like a simple assault punishable with 1 year imprisonment. Are you following me now?
Yes, sir.
Yeah, baby.
Uh-huh.
Yes,
So,
my love.
So I have a
the
question.
statutory framework.
Oh, now it's a
Okay, what's
I've
your
never ever
question?
asked this question before.
All right. So
Should
my
I read it?
question
Should I
is,
not read it?
was the assault against the assault between the husband and wife? If the husband has touched the wife at probably those points where it should be termed indecent assault, would it still be assault simpliciter because they are married?
Well, is
I did it now, now. I asked all these questions.
the question is the answer to that question is neither here nor
Yeah,
there,
baby.
and I will tell you the reason. Husband and wife, you know, we have marital rape exception under the criminal code. Oh, there is marital rape exception. Okay, so if a husband is allowed to have intercourse with his wife without necessarily seeking her consent, simply because they are in a marriage. And you know that the issue of sexual intercourse is actually preceded by a foreplay. And foreplay requires that you can have contact, you know, with some parts of the body of the woman, which includes the pubic area, the buttock, and the breast.
Oh.
Aha. So if intercourse without consent will not amount to rape, I wonder if it will amount to indecent assault if we touch such places. But I think what aggravated Odushote and Alausa's case is the issue of shaving. If it had been a mere touching, the case wouldn't have come up. But it has to do with shaving a person's pubic hair without her consent. You know, that must have been what made it to be, you know, worthy of litigation. Otherwise, if it had just been a mere contact, it will pass. I hope you understand what I'm saying now.
Yes, sir. Thank you very much, sir.
So the statutory framework for indecent assault in Nigeria is Section 360 of the Criminal Code. Section 360 of the Criminal Code. And what this section does is that it provides that who unlawfully and indecently assaults a woman or girl guilty of a misdemeanor and is liable for 2 years. That assault, indecent assault, is the punishment can be as low as 2 years, which is a misdemeanor. Any person who unlawfully and indecently assaults a woman or a girl is guilty of a misdemeanor and is liable to imprisonment for 2 years. However, in Lagos, and I'm not talking of criminal law of Lagos State now, because the criminal code actually specifies that if it is in Lagos, if the assault, the indecent assault, is perpetrated on a girl below 13 years, that the punishment will be 3 years imprisonment. But if on a girl that is above 13 but below 16, the punishment will be 2 years. So you can now see this kind of differentiation, even in the criminal code. But generally, Section 360 covers the field. But in Lagos, if the indecent assault is perpetrated on a girl that is below 13 years, then it becomes a felony, punishable with 3 years imprisonment. Okay? And you also have to note the impact of the Child Rights Act, which has now increased the age of a child to below 18. So that has overtaken the prescription of 16 years in the criminal code. A child now is a female child now is a girl child that is below the age of 18 and no longer the 16 in the criminal code. Okay, so section 222, yes, section 222, that is where the consent age is graduated. Section 222 of the criminal code. So you have to note at this junction that consent can also be vitiated in the case of indecent assault. Consent can also be vitiated, especially by fraud or misrepresentation. Consent can be vitiated in the case of indecent assault by fraud or misrepresentation. So just like in the case of rape too, consent obtained by force or fraudulent representation as to the nature of the transaction is no consent. Fraudulent misrepresentation as to the nature of the transaction is no consent. So if you can still recollect the facts of R versus Williams and R versus Flaherty in the case of rape, we also have similar instances in the case of indecent assault. And on this note, I want to comment to you the case of R versus Tobasum. R versus Tobasum. Tobasum is spelled T-O-B-A-S-S-U-M. T-O-B-A-S-S-U-M, 2003 Criminal Appeal Report at 328. In Tobasum, the defendant was a fake medical doctor. He was a fake medical doctor. Women to allow him to measure their breasts. He persuaded women to allow him to measure their breasts by representing to them that he was doing so for the purpose of a breast cancer database. That he was trying to build a breast cancer database, which for medical doctors. But simply because he was a fake doctor and his claim was a fraudulent representation, he was convicted for indecent assault. And on appeal, his conviction was upheld. Are you following? That is Tobasum. And in the same vein, a similar vein, in R versus Pike, Pike is spelled P-I-K-E, 1996, one criminal appeal report at page 4. The accused person was held guilty of indecent assault because he talked a woman into believing that he was a doctor and submitting to intimate examination. The woman assumed, based on representation, that the man was a doctor. As a woman, or usually as a patient, you submit yourself to medical doctors for examination. And some of these examinations can be very intimate. And you know what I'm talking about. Only to discover later that the man was not a doctor. So it was held that the acts of the man in Pike amounted to indecent assault. So we now need to talk about the innovations in the criminal law of Lagos State, 2011, on this issue of indecent assault. Okay, we have assault occasioning penetration, and we have assault without penetration. So if it is assault without penetration, it is just punishable with imprisonment. But assault with penetration attracts life imprisonment. So you see the provisions of section 2 and 261 of the criminal law of Lagos State. Sections 259 and 261 of the criminal law of Lagos State as regards assault occasioning penetration and assault without penetration. So the significance of this is that in cases where the offense of rape cannot be substantiated, where the offense of rape cannot be substantiated, that person will still be convicted for assault occasioning penetration. You know, because here it is not specific, unlike the provisions for rape in criminal law of Lagos State, which still requires penile penetration. So assault here does not need to require penile penetration if it involves penetration, which can be by an object like cucumber, and which can be into the anus rather than, you know, the female genitalia, and so on and so forth. It will still come under, you know, it will still be punished with life imprisonment, and it will pass for assault occasioning penetration, even though it will fail under rape. And you know the punishment for rape is life imprisonment. So this one is also punishable with life imprisonment. So you have to note this. However, if it is assault without penetration, it is punishable with 3 years imprisonment. So you now see that the provision of the criminal law of Lagos State is a bit tougher than that of criminal code. Simply because criminal code, especially in case of Lagos, graduates the age of consent. If it is 13 years but below 16 years, it's a misdemeanor. But if it is below 13 years, 3 years, felony. But the criminal law of Lagos State now just made a blanket provision for assault without penetration. And it's punishable with 3 years imprisonment, which is a felony. So whether it is on below 3 years or above 3 years, there is no differentiation. Okay? For example, now,
So I have a question.
Yes, what's your question?
My question is concerning Section 360 of the Criminal Code. You said that
Yes.
in Lagos, it is specifically below 13, that if it is below 13 years, then it will be 3 years imprisonment. Then you said that the Child Rights Act increased the age to 18. And then you also now said that the age of consent in the criminal code is 16.
What you are saying is Section 222, not 360. 360 did not talk about age. It's Section 222 that graduates the age of consent of the criminal code.
Okay, sir. My question is that how can we reconcile these 13 years in Lagos and these 16 years in the criminal code that you talked about, sir? The one that you said when the person is below 13 years.
That Section 222 that graduates the age of consent has been overtaken by criminal law of Lagos State, because that applies to Lagos. And now that we have criminal law of Lagos State, so the criminal law of Lagos State now is no longer graduating ages. So criminal law of Lagos State is having cognizance of the Child Rights Act. So the position in that criminal law of Lagos State now is that if you have unlawful contact with the body of another without the person's consent, it amounts to assault without penetration. It's punishable with 3 years imprisonment. So it doesn't matter your age or whatever. In fact, it doesn't have to do with gender, regardless of the gender. So it's so wide. I don't know if you understand what I'm saying. It's so wide, it accommodates indecent assault. Hello?
Okay, sir. Thank you, sir. Yes, sir. I can hear you.
It accommodates indecent assault, but it's just a blanket punishment of 3 years, which is a felony. Okay? So example of
Sir, I have a question. Sir, I have a question. My question is about consent. Like, what if you didn't know the age of the person, or what if the person like told you like a different age?
Well, it's a matter of evidence. It's a matter of evidence. You know, although that may not be in defilement, but for indecent assault, there are certain defenses that you assume the person is of so age, maybe because of the body structure or the disclosure of the girl, and so on and so forth. So for indecent assault, it can be a defense, but for defilement, it is not relevant.
Thank you,
It's not
sir.
relevant. Yeah. So now,
Sir, I have a question.
okay, quickly.
Okay, sir. So my question is now that the Lagos State law has like a blank law
Yes,
concerning that,
yeah.
a blanket concerning that is rape, but does it have one for when rape has been established that it will make the punishment more than that of 3 years, or whether it
No,
is
no. There is a provision for rape in the criminal law of Lagos State.
Okay, sir.
Are you following me? There
Yes,
is a
sir.
provision for rape in the criminal law of Lagos State. Okay? And that provision punishes rape with life imprisonment. You get what I'm saying now?
Yes,
That's
sir.
the section 258 of the criminal law of Lagos State provides for the offense of rape, and it is punishable with life imprisonment. But the only problem with that provision is that apart from recouching the element of any person in section 357 of criminal code to now mean any man, to cure that defect, is still talking about penile penetration. He's still talking about a man, only a man can rape a woman, and that a woman cannot rape a man. Okay? And these were
Yes.
problems of the criminal code, which were carried over into the criminal law of Lagos State. But whoever fails to pass that requirement in section 258 of the criminal law of Lagos State can still be punished under section 261 of the criminal law of Lagos State, because if there's no penile penetration, or if the place that the penis was thrusted into was not the female genitalia, maybe anus, it will not pass under section 258. That is the provision for rape under criminal law of Lagos State. But that person will still be convicted under section 261, which punishes assault occasioning penetration with life imprisonment. That's the same punishment with rape. But it is more liberal. It is liberal. It doesn't require that it must be penis versus vagina. It does not require that it must be vagina specifically. It does not require it has to be penis. I hope it's clearer now.
Yes,
No,
sir.
because
Thank you very much, sir.
these are areas where we test student knowledge.
Thank you, sir.
If you look at past questions, we'll give you scenario where somebody used penis to penetrate. Then we'll ask you, will your answer be different? Assuming you use cucumber instead of penis. Some of you who are not careful enough, you just say that he will not succeed for rape in Lagos. But you will not go further to say, however, under the provision of section 261 or 259 or so, that even though he didn't use penis, using cucumber still attracts life imprisonment. I hope you are getting what I'm saying now. So you must be able to distinguish and distill the differences in those provisions as it relates to their peculiar requirements.
Thank you, sir.
Okay.
Yeah, good
So-
morning, sir. I have a question.
Yeah.
Sorry.
Okay.
Yeah, I'm very curious as to the existence of hermaphrodites in these cases, because we have some females who have both male organs and female organs. So what if the female with a male organ rapes or has an unlawful carnal knowledge with a guy? Does it also amount to this? Because I see that we have considered any person as given by section 257 in the criminal code as a misnomer. because we have said that the provision is basically a crime against female. So what about a female who has a male organ carrying out rape or having unlawful carnal knowledge over a guy? Does it also amount to that?
Are you talking of cases of people like Bobrisky?
Bobrisky is not, I don't think he's an hermaphrodite.
But
What
sometimes
about
they
people
said
with,
he's a
I'm talking about
transgender.
people with both
No,
male and
Bobrisky
female
was
organs.
said to be a transgender.
Yeah, so there are other people
So
who
I
have
think Bobrisky was a male and he later changed
changed.
to a female.
Yes, that's a different thing. We have people who
So
have,
when they put him in detention, they were using a pronoun of a female for him, and there was confusion whether to put him in male cell or female cell.
I agree with you, sir. But that's a different thing altogether, because we have
Yeah,
people
you see,
who
when you are talking of hermaphrodites, let me tell you,
yes,
you
sir.
see, it is not difficult. If it says any person, and which you are quarreling with the phrase any person, and it now changes in the criminal law of Lagos State to any man.
Exactly.
Okay, you are talking of hermaphrodite. That is, if you are an hermaphrodite,
Mhm.
you belong to both genders. I hope you agree with me.
Yes, sir.
So, for the purpose of committing the offense of rape, and you use your male organ to penetrate the female genitalia of a lady, you have satisfied the requirement under Section 357.
Okay.
And you have satisfied the requirement also under criminal law of Lagos State, because for that purpose you are a man, and you have used your male organ.
Okay.
The requirement is that you use penis and you use penis. You thrust it into a female genital and you have done that. So what else do we need? It is immaterial whether you also have female organ.
Well, for me, I would have thought that the Section 357 covers every person as against the restrictive nature of Section 258 of the Lagos Criminal Law of Lagos State.
258 says any man.
Yes, so it's restrictive as to gender.
257 says any person.
Yes.
So if you are now saying any person,
yes,
and the law of rape says that it's only a man that can rape a woman, that a woman cannot rape a woman. So why putting any person?
So because I think they just capture all the gender, also hermaphrodites, and any possibility of having unlawful carnal knowledge. I think that it is all encompassing as against being restrictive because of the existence of this class of persons.
The contemplation of the drafters of the law was not in terms of hermaphrodites. The contemplation of the drafters of the law was, we are talking of 1958 or something like that. Contemplation was, we have two genders, male and female, and we have two sexual organs. That is the penis and the vagina. I mean, there is no contemplation that somebody will be there halfway or whatever. So don't let us take it out of context. Okay. You understand what I'm saying? I know you are trying to, raise concern about the contemporary developments and so on and so forth. But let's look at the criminal code within the context of the intendment of the draftman as at 1958 when it was being enacted.
All right, sir. Thank you so
much. You understand what I'm saying now?
Yes.
And that is why we will now have subsequent legislations up to the contemporary era. And you can see that there were developments, for example, even the same criminal law of Lagos State made provision for a situation where somebody fails to satisfy the requirement of Section 258. And says that person can still receive the same punishment of Section 258 if it can be established that the sexual, that the assault involves penetration. And that penetration does not have to be the female organ. Even if it requires penetrating something into the air lobe, or even to anus, or any orifice. And it can be from a male to a male, male to female, and so on and so forth. So it's so wide. And you can use objects. You will not necessarily use any part of your body. You can use objects. So it's so wide. And you still have the same punishment with somebody that was convicted for rape. Because a lot of people have been escaping justice. Instead of having punishment for rape, because you cannot satisfy the requirement of rape, they may just say attempted rape or assault. And that, in most cases, can be like 3 years. So for those people to not to be escaping justice, that is why these provisions of Section 259 and 261, came up in the criminal law of Lagos State to take care of those cases.
So I have a question, please.
Yes.
Okay, so I basically need clarification because this is concerning a past question that I encountered.
Yes.
So when we're talking about rape, I think you've established that the main thing here is unlawful carnal knowledge, right? Which means that also includes someone you're not married to. But
Yes.
the way this past question was phrased, it implied that the man and woman already were having an affair, even though they were not married to each other. So,
Yes.
but then on this particular night, they lodged at a hotel, and then, they lodged at a hotel with their respective spouses. But the guy left the bar and went to the other guy, to the other woman.
You said hello. You said
Yes, I can
respective
hear you,
spouses.
sir.
You said respective spouses, but you said the way the question was formulated, they didn't say that they were husband and wife.
They were not husband and wife, sir, in the question.
Can ordinary partners be described as spouses? What's the meaning of
No,
spouse?
sir, you're not getting me, sir. Maybe I'm not communicating correctly. What I'm trying to establish is that there's a guy and he's married, and there's a woman and she's also married, but they work in an office and they are having an affair. So there's already
both of them are married to different men and women, or they are married to each other?
Sir. No, they're not married to each other. They're married to different men and women.
Go ahead.
Yes, sir. So, but in the question, yes, the question was directed that the woman's husband planned a vacation. Then the guy heard about it and took his own wife to the same destination. Now,
yes, I'm with.
Yes. Then on a particular night, the guy left the bar. So he had earlier gone out to drink. He left the bar and then went up to his co-worker's room. That's the woman he was having an affair with. And then started touching her. And then at some point, it trusts something inside of her. So, and then the husband of this woman came in and called the police. That's the way the question was framed. So I feel like, although the man is not although the woman is not his wife, there's an implication of consent that they do this before or something like that. I don't know. The prospect of unlawful carnal knowledge, does this still apply there?
It will not. Let me tell you, we set the question you are talking about.
Yes.
And the area we are trying to examine students in that question, one, we are trying to examine your knowledge of whether defense of intoxication will avail the man, because they left the pub, they went to drink. I hope you are aware of that.
Yes, sir. Yes, sir.
Whether defense of intoxication can avail him. And since the intoxication was a voluntary intoxication, we just discussed that it will not avail. Okay. We also wanted to test the knowledge of students on defense of mistake. Whether defense of mistake can avail the man. And you see, the way we couch it, by the time you open the door.
What area?
Hello?
As a mistake in what area?
Mistake of fact. Is it not the case of a man who went to a different room where another person's wife was?
Okay.
And assumed that it's his wife. And the wife also assumed that it's her husband that came in.
No, sir. I think so sir, that's the thing about these questions. I think it's very complicated because the man, the indication there is that he knows that was where she was going to be. Yes, he had drank at the pub, but it almost feels like it's because I think the complicated thing there is that the question established that they are in this some sort of dalliance, like a love affair. Is that immaterial to the fact of what is happening that night? Because he left the pub, but it didn't indicate that he mistook her. It was intentional. That was the question, sir. And then the question also said that
I'm not sure you read that question correctly.
Okay, can I say something, sir?
The one that we said, two couples went to hotel, maybe for vacation or whatever. They left their wives in the respective rooms, which was before the other. And the two of them took some drinks. And afterwards, one of them stood up and left the other at the bar. To go to his room now, he now went to the wrong room where the wife of the other one was, assuming that, thinking that it was his own room. And he opened the door, which was not locked with key, and there was darkness. The light was off. And the wife, who was expecting her husband, assumed that the husband has come. And without talking to each other, the man just removed his trouser.
No, sir. No, sir. No, sir. No, sir.
The woman now accepted, and midway into the intercourse, the woman suddenly discovered that this is the wrong person.
Sir,
and raised an alarm, and it became a police case.
No, she did not raise an alarm, sir. No, that's not the question I'm talking about, sir. That's actually why I'm bringing this up. She did not raise an alarm. Apparently, she was mad at her husband. So when the guy started touching her, that's her legitimate husband, when the guy started touching her, she resisted, thinking that it was her actual husband. But then when she opened her eyes, because the question said she opened her eyes and saw that it was Goku. So she saw that it was the guy from her workplace that she was having the affair with. Then she yielded. It was now her legitimate husband who came in and called the police. I don't understand the question, sir.
Okay, now you are saying that when the wrong man entered the room, the woman closed her eyes that time. So
her eyes were closed at that time.
At what point did she open her eyes? Is it when the intercourse was on?
Okay, so she said no, the point where she opened her eyes is when she had been stimulated by foreplay.
Okay, but the intercourse has not begun. It has not begun then.
Yes, sir.
Okay.
Yes, sir.
When she now discovered that, wait. During foreplay, she opened her eyes and saw that this was not my husband.
Yes,
but
sir.
she still continued to permit the man to go on. Is that what you are saying?
Yes, sir.
You continue to permit the man to go on.
Yes, sir.
And then the intercourse becomes unlawful. Carnal knowledge becomes unlawful. It becomes unlawful.
But what of our consent? What of our consent? Because later
these requirements are conjunctive. They are not disjunctive. The actual source element is that there must be a carnal knowledge which must be unlawful. In this case, there was a carnal knowledge which was unlawful. Then the menstrual element is that there must be an intention and there must be knowledge of the unlawfulness of the, of the carnal knowledge. Knowledge of the unlawfulness of the carnal knowledge and knowledge of absence of consent. So in this case, there was consent. But the intercourse, the carnal knowledge was unlawful. So partially, the requirement of rape is met. The actual truth element is there. You understand what I'm saying now? They are not husband and wife.
Yes, sir.
So it's an unlawful carnal knowledge. Even if there was consent.
Yeah, exactly what I was asking, sir.
But I wouldn't personally, set a question that way because we don't want to confuse our students. Okay? So we set questions that are clear and direct, and we have our goal, we have our mission. Okay? If
All
you
right,
set
sir.
a question where you are talking about unlawful carnal knowledge, and you are at the same time talking about the issue of grant of consent, it can be confusing. It can be confusing. So we don't say, like the one I gave to you now, yes, I said that question. And it's so direct and straightforward. So you can look at the defense of intoxication, look at the defense of mistake. Then you can adumbrate. You understand what I'm saying? So you don't
Yes,
lump
sir.
the issue of unlawful carnal knowledge with presence of consent. It can confuse students. So I can assure you, you can't have anything like that again.
Okay, sir.
So let's make progress. So in the case of R versus
Thank you,
court,
sir.
court is spelled, yes, court is spelled C-O-U-R-T. In R versus court, C-O-U-R-T, 1989, AC 28. We are looking at example of indecent assault. The defendant spanked the buttock of a 12-year-old girl. The defendant spanked the buttock of a 12-year-old girl because it gave him sexual gratification. Because it gave him sexual gratification. It was held to constitute an indecent assault. However, if the act of assault does not have any element of indecency, it will not amount to indecent assault. If the act of assault does not have any element of indecency, it will not amount to it. I gave you instances of indecent assault. The types of assaults that can be classified as indecent, especially indecent assault on a woman. And I gave you aspect of touching a woman's buttock, touching her breast, touching a woman's buttock, touching her breast, and also touching her pubic area. Those are three major areas in a lady's body. So if you touch a lady's head, to what extent can it amount to indecent assault? If you touch a lady's leg, to what extent can that assault be indecent? It is an assault, quite all right. But does it pass to be an indecent assault? The answer is no. So in the case of R versus George, however, in R versus George is 1956 CLR at 52. George is 1956 CLR at 52. The defendant attempted to remove a girl's shoe because it gave him sexual gratification. Some people who are like imbecile. How does removing a girl's shoe give you sexual gratification? So the defendant in this case attempted to remove a girl's shoe because it gave him sexual gratification. But the court held that there was no indecency in the act. There was no indecency in the act. So quickly, before we run out of time, let's proceed to defilement. Let's proceed to defilement. We have about 30 minutes to go. Let's proceed to defilement.
Sorry, sir, I have a question.
Yes.
Sorry, sir.
Yes.
Yeah, the indecency, it doesn't have, my question is, for the indecency in this case here, it doesn't have to be about the act. I'm sorry, it doesn't have to be about the intention. It has to be about the act, meaning the man's act itself. The man's intention, was indecent, for the act, he said he was not indecent. So my question is, what if the man's act is indecent? Can he still, be his intention rather than his act? Because the intention is clearly indecent, but the act itself will not be indecent. So where the intention is indecent, would you still be held liable?
You see, when we talk about concurrence of actus reus and menstruum, under the Latin margin, actus non facultatum nisi mensitur, there must be a concurrence. The two must be present. Okay? The two must be present. Are you following me? So
Yes.
in this case now, the man had an intention of indecent assault, but his act negative that because there was no indecency in the act. And that's why he was not convicted for indecent assault. So there must be an intention to carry out an indecent act, and your act itself must be indecent. I don't know if you are following what I'm saying. There must be concurrence of actus reus and mens rea.
Okay. Thank you, sir.
Yeah. So defilement. What is defilement? What is defilement? Defilement means to desecrate, or to debase the pureness of something, to debase the pureness of something, to desecrate or to debase the pureness of something. So we are going to look at the definition in Black's Law Dictionary, where it was said that defilement occurs when one performs an unlawful carnal act on a girl child. Take note, girl child, that's the object. Defilement occurs when one performs an unlawful carnal act on a girl child, thereby debasing, dehumanizing, and violating her person. Girl child, thereby debasing, dehumanizing, and violating her person. And the rationale for criminalizing defilement, defilement is to punish those who will escape rape. Is to punish those who will escape rape on the ground of consent. See now, to punish those who will escape rape on the ground of consent. You see, by way of preliminary remarks, let me tell you that the elements of rape and defilement are basically the same. But as I will go further now, you will see the actus reus element is unlawful carnal knowledge. You see the mens rea element is intention and knowledge of lack of consent. So intention and knowledge of the unlawfulness of carnal knowledge. Because the requirement of consent is the main differentiating factor. In rape, there must be absence of consent. But in defilement, consent is immaterial because a girl child is deemed to be so young and as such cannot grant a valid consent. Okay? So you now see the difference. You know, consent is immaterial in defilement. Consent is a sine qua non for rape. That's number one. Number two, defilement is targeted at girl child. Rape is targeted at adult girl or woman. Number three, defilement expands to cover the scope of idiots and imbeciles. You know, idiots and imbeciles. It's a misdemeanor. Idiots and imbeciles are the mad people. You know, when some people are psychopathic or suffering from schizophrenia, you know, some of them will laugh when they are supposed to cry. So you can approach a mad woman under the bridge and make advances to her, and she just laughs and gives you an impression that she's trying to welcome you. But the woman is mad. She doesn't know the nature and quality of her act. And that suggestive consent is not valid in law. And that is why if you have intercourse with an imbecile or an idiot, it is deemed to be a defilement. And that is why we used to test students' knowledge in this area by using example of somebody who is suffering from Down syndrome. Down syndrome, you know what it means to be a Sandwich syndrome person? You know, all these, you know, people that are imbeciles and so on, they are suffering from Down syndrome. So when you see things like that, you should know where we are talking about, where we are going. So it comes under defilement. It's also punishable with 2 years imprisonment. It's a misdemeanor. You know, it's a misdemeanor. So, like I said, the rationale for criminalizing defilement
Hello,
is to
sir.
punish those. Yes?
Hello, sir. Please, I have a question.
Yeah, what's your question?
So a situation once happened in my church where, something like there's this guy is not exactly he's a bit mentally retarded. Like when he talks, you can see that he's not an imbecile, but he's like an idiot, something like that. And then he one day during service, the ushers went to the back and then they found him trying to have sexual intercourse with a girl of about 12 years. But now the matter is that it was actually the girl that was proposing for the what's name. She was the one, like, instigating the action. He wasn't the one that was saying 12 years. 12 years.
Yeah, go ahead.
So it still comes under defilement, right? Because consent is immaterial. It does not matter that she was the one that was actually.
There are two issues involved in the scenario that I brought up. The first issue is that the guy himself is an idiot. His own line of defense for doing whatever he did may be in the line of defense of insanity. Though God will help him if he can satisfy the requirement in section 28 of the criminal code, which is tough. But for the girl, 12-year-old, is a girl child. And the mere fact that she consented is immaterial. So the offense of defilement is established.
Sir, but this is not just about consenting. It's like she's the one that instituted the action.
That's what I'm saying.
So it's not just that she consented.
He's not supposed to play along with her. He's not supposed to play along. It doesn't matter whether she instituted it or initiated it. It doesn't matter. She's a girl child. It takes you to tango. It is immaterial whether she initiated it. A mad person can also initiate sexual intercourse. It is for you to know that go there, move on, but life go get out. For you to play along with that person, you have entered the web.
So what if the girl was a girl child, 13-year-old, and the other guy was an imbecile? What would have happened in the case?
If the girl is 13-year-old,
yes, and the guy is an imbecile.
The girl is normal.
Yes, and she instituted it, but the other guy is an imbecile.
And that is what I'm saying. We are saying the same thing. We are saying the same thing, that if the girl is below 13, definitely that is life imprisonment. But it is now left for the guy who is an imbecile to be able to put up a defense of insanity if he can be successful. Okay. Which I doubt. So that is it. So I said the law of defilement.
So what if it's an adult?
Wait. Reserve your question. Let me conclude this aspect. Then there will be time for questions. Reserve your questions. Because some of these concerns that you are raising, maybe we are still going to touch on it, before the end of this class. So, but if I finish and you still have questions, you can raise it. So I said the law of defilement is also aimed at protecting children who may not be able to give valid consent due to their young ages. And it is a form of sexual abuse, which can also involve coerced or forced sexual activity. So it is not in all cases that defilement entails the offer or grant of consent. You can also, as an adult, have a forceful intercourse with a minor, with a girl child. So what we are saying is that whether with consent or without consent, it amounts to defilement. Okay? So girls are generally vulnerable to sexual abuse from relatives, uncle, house boy, and so on. Teachers in school, of course, we know that, and people in the community, So in most cases, the girls are threatened not to report the abuse. and it is an act of pedophilia. It is also referred to as statutory rape in some jurisdictions. Somebody brought a rape case to me recently. They have a daughter of, brought a case of divorce, rather, to me recently, which I'm handling presently. And the woman was telling me that the daughter informed her, because they have separated for 5 years. The husband has relocated to US. So the wife is here. And they have a daughter who is now 8. And this woman was telling me that the daughter told her that when she was 3 years old, that the father, that's the husband, abused her, defied her. But as she kept it to herself all this while, but as she just thought that, look, I just have to, voice out, and she just told the mom. And the mom started crying when she came to me. I said, no, stop crying. It's a display of psychosis. It's not normal. 3-year-old daughter by the father. You can imagine, a normal person will not do that. So these things happen. It happens a lot. But the girl kept it to herself for quite a long time. She made the voice clip, which was sent to the man, and the girl was talking that, Daddy, what you did to me the other time, I've decided to tell my mom. How you molested me, I've decided to tell my mom. So these are issues. These are issues. So now we look at the statutory framework for the offense of defilement. And first and foremost, we are going to look at section 218 of the Criminal Code. And it provides that any person who has unlawful carnal knowledge of a girl under the age of 13 years is guilty of a felony and is liable to imprisonment for life. Imprisonment for life here, take note, is in the same category with the punishment for rape, which is also life imprisonment. Okay? The section also proscribes any form of attempt or unlawful carnal knowledge of a girl below 13 years. So, attempt to defile attracts 14 years imprisonment. Attempt to defile attracts 14 years imprisonment. So how do you know where attempt stops and where the actual perpetration of the offense begins? I'm sure you are taught attempt and conspiracy. Were you, or you are not taught?
Yes,
We
sir,
were
you're
taught
done.
You still remember all your tests? Your equivocality test, cinematographic test, last act test, and so on and so forth. You still remember? Eggleton? You still remember? You
Yes,
have
sir.
forgotten. So now, attempt to defile attracts 14 years imprisonment. Section 282 of the, but before we even go to penal code now, we also look at section 221 of the criminal code. Section 221 of the criminal code provides that any person who has or attempts to have, so now both acts and the actual commission attract the same punishment. Any person who has or attempt to have unlawful knowledge, carnal knowledge of a girl, being of 13 years and under 16 years. Now, like I said, by virtue of the Child Rights Act, the age of a child has been taken to below 18 years. So you should be able to fill the gap. Knowing a woman or a girl to be an idiot, you see now, or you see, so a girl or a child being of 13 and below 16 or 18, as the case may be, or knowing a woman or a girl to be an idiot or an imbecile, has or attempt to have unlawful carnal knowledge of her, is guilty of a misdemeanor punishable with 2 years imprisonment. So you now see section 218 is talking about a girl below 13 years. That one is life imprisonment. But section 222 2:1 is talking of a girl above 13 years but below 16 years, or who is an imbecile or an idiot. So it doesn't matter whether it's a girl or a woman. It can be an adult. So if you have carnal knowledge with such a person, it constitutes defilement here, but it is a misdemeanor punishable with 2 years in prison. So who can tell me the reason for the differentiation in this punishment? If a girl of 13, or let me say a girl of 12, is defiled and the perpetrator is punished with life imprisonment, but a girl of 14 is defiled and the perpetrator just gets 2 years imprisonment. I mean, you can imagine 2 years life imprisonment, difference of 2 years. Why 12 years, 14 years? Why should there be a difference in the punishment? Can somebody quickly give me a conjecture? I'm not hearing anybody. Nobody is saying
because one is
anything.
a minor?
Huh?
Is it because one is a minor?
Both of them are minors.
I think it's because of the
14.
consent.
They are both. You see, the reason is this. Let me tell you. When a girl is 14 years, 15 years, she already has the apparition of a mature girl. You know, you start having breasts, developing breasts. Some girls at 14 will have started menstruating, even 13. I don't know if you understand what I'm saying. So they already have the sexual attractions, the bodily features. So it is believed that they are getting close to the age of valid consent. They are getting close to the age of valid consent, and that at that stage, they can be able to know what they want and what they don't want. But for a girl that is below 13, it is believed that she's so young, she cannot know her right from left, and she's still very innocent, you know, just a small girl. You know, unlike a lady that has started developing the features of a mature girl, and whose mental state has also grown, developed to the extent of knowing when to say yes and when to say no. Are you following me now? And why they classify those ones with the imbeciles and the idiots, women and girls, is because those ones also cannot say validly what they want and what they don't want. So that is very important. So, but the penal code, like I said, the penal code, by virtue of section 282, also makes it an offense for a man to rape a girl below the age of 14. So note the distinction now. Below the age of 14, and punishes him with imprisonment for life. So this one did not, you know, graduate it below 13, above whatever. Just say any girl below 14, life imprisonment. Okay. What is the actus reus of the offense of defilement? The actus reus, like I said, is the same thing with that of rape, and that is unlawful carnal knowledge. Having unlawful carnal knowledge. And the definition of unlawful carnal knowledge is as has been given to you pursuant to section 6 of the criminal code, which means intercourse between a man and a woman who are not husband and wife. Intercourse between a man and a woman who are not husband and wife. So it will be construed from the foregoing that intercourse between husband and wife is lawful carnal knowledge. Intercourse between husband and wife is lawful carnal knowledge. But there are some controversies around here. So I'm going to take you to Uganda now. In the Uganda case of Uganda versus Kario Zawade, Uganda versus Kario Zawade, Kario is K-A-R-I-O-R, Zawade is Z-A-W-A, Z-A-W-A rather, double-D-E, Z-A-W-A, double-D-E. Criminal section number 551/90, High Court. The court held that once it is established that the victim is below 18 years old, you know, this particular case in 1990 in Uganda, they have already pegged the age of majority at 18. And Nigeria only did that recently by virtue of the Child Rights Act, I think 2013 or so, you know. So, or 2003 rather. So you can now see, as far back as 1990, Uganda has already pegged their age of majority at 18. So it's saying that it is established that once the victim is below 18 years old and there is intercourse, it automatically becomes unlawful. And that is the position in Nigeria today. That is the position in Nigeria today. Those of you who date underage girls, you know, these days, to enter university, age of 16, you see undergraduates at 16, they are already having intercourse. That is unlawful carnal knowledge. Any girl below 18 that has intercourse is unlawful carnal knowledge, regardless of whether it is between husband and wife or not. And that is another issue that we are going to discuss now. You know, in some jurisdictions, the Sharia states, a lady that is up to 13 years is eligible to marry. 13-year-old is eligible to marry. So how do we reconcile that with the provisions of Child Rights Act, which pegs the age of majority to 18? If a man marries a 13-year-old girl in Zamfara and has intercourse with her, has he committed any offense? It's covered by their law because they are married. But in the South here, if you marry any girl below 18 years, you have committed an offense. You can't marry because that girl is not up to age of marriage. And that's the problem. So it doesn't matter whether you say, she's my wife, legal wife. No. We have age of marriage in southern Nigeria. So in Zawade's case, the moment the victim is below 18 years old and there's intercourse, it automatically becomes unlawful. And I put a poster here, whether it applies to jurisdictions where marriages to girls of 13 years old or below are permitted. But we must know that the emphasis here is on Section 6 of the Criminal Code, which is based on marriage rather than age. Section 6 played emphasis on marriage rather than age. But the emphasis of the Child Rights Act in Section 31 is age of 18 years, regardless of marriage. So you must be able to reconcile the two, marry together. So the menstrual of the offense of defilement is intention to have unlawful carnal knowledge and knowledge of the unlawfulness of the carnal knowledge. You see now, it's almost similar. The only difference here is that for menstrual of rape, unlawful, the menstrual of rape is intention to have unlawful carnal knowledge plus knowledge of lack of consent. But in defilement, since consent is not a sine qua non, it is intention to have unlawful carnal knowledge plus knowledge of the unlawfulness of the carnal knowledge. Take note of that difference. You know, so it is immaterial as consent or not. Unlike in the case of rape, lack of consent is a sine qua non. The children cannot offer any valid consent, just like the idiots and imbeciles. There are special requirements for prosecution of defilement charge. The first one is the time frame for prosecution. Prosecution must begin within 2 months of the time of the alleged commission of the offense. Otherwise, it becomes statute barred. Prosecution must begin not later than 2 months after the commission of the offense. And this is not applicable to rape. So you should know the difference here. So I'm going to comment to you the case of Mayaki versus the state, 1981, 1 NCR at 25. Mayaki is spelled M-A-Y-A-K-I, where the accused was charged with defilement after 2 months of the commission of the offense. But the court held that the appellant could not be convicted of the offense. The court held that the appellant could not be convicted of the offense. The second special requirement is corroboration. A person cannot be convicted for the offense of defilement upon the uncorroborated testimony of one witness. This is a condition precedent which must be fulfilled before an accused person can be sentenced under Section 218 of the Criminal Code. So the evidence of the prosecutrix must be corroborated due to her tender age, which makes it undesirable to solely rely on her evidence. You should
Sorry, sir, I did
compare
not
this
get
with
that
the case
number
of rape. Corroboration is very, very important. It's a requirement for the prosecution of defilement. You can't rely on the evidence of the victim alone because of her tender age. So it is believed that the evidence may not be reliable. So there must be another person to testify to corroborate the fact that it took place. And I said you should distinguish this from the requirement in rape cases, whereby in the case of Popola versus State, the requirement of corroboration has been jettisoned in rape case. And you should know the reason is that in rape cases, we are talking of adults. So it is believed that an adult knows what she's talking about. But when it comes to defilement, a minor may be inconsistent and incoherent. Okay. So under the criminal law of Lagos State, sexual intercourse with a child is punishable with life imprisonment. A child under the Child Rights Act is a person below 18 years of age. See Section 137, Criminal Law of Lagos State. There's also no defense of mistake, can you see now? Or assumption of older age due to appearance. And note also that Section 219 of the Criminal Code extends punishment to owners of premises where the Defilement Act purportedly took place. Owners of premises. And the law imposes the same punishment as the actual perpetrators, depending on the age of the victim. Note finally that in Uganda, the punishment for defilement has been increased from life imprisonment to death penalty. See Section 123 of the Uganda Penal Code, 1990. So we have like 1 minute for questions before the time elapses. So at that juncture, we put paid to my part of the topics for this semester. So I now invite questions now before we depart.
Sir, you mentioned corroboration.
Yes.
As they don't rely on the testimony of the victim. So
Yes.
and you said
the testimony of the victim only. They don't rely only on the testimony of the victim. Unlike in rape cases, where confessional statement of the victim alone may be used to convict him.
Yes, sir. So my question now is, you mentioned that you need testimony from somebody else, a witness.
Yes.
So can they also use maybe the sperm that was found in the vagina of the child as corroboration? Not just, you can add it to the testimony from the victim.
That can proceed from the medical doctor. That can proceed from the medical doctor that examined the victim after the incident.
Okay. Thank you, sir.
Sir, okay, good morning, sir. Sir, you mentioned that you have a case that a woman reported that the child was molested around when she was 3 years. Yes, and she's reporting now that she's about 8. In cases like that, how do you prove, being that is a testimony of a child that needs to be corroborated?
Well, I just advise the mother to put it off her mind, because the case she brought before me is for a case of divorce, and to get divorced, it suffices if the couple have lived separately for a minimum of 3 years. And since they have lived separately for a minimum of 5 years now, they have satisfied that requirement. So it will be a surplusage to now bring in that particular development, which may be difficult to substantiate.
Okay, so she can only use it as a ground for divorce, not.
It's not necessary, because if you try to use it, it will be difficult to substantiate it, because the girl did not report it as at that time. There was no police report. There was nothing, and 5 years ago. So who even knows whether it's a concocted, story? So it may not really have weight. So I ask her to forget that one, and let us concentrate on the fact of separation. Yes.
Hello, sir.
Yes.
I want to know, in the case of this collaboration, you said the underage child's statement is not enough to be used as an evidence.
Yes.
And now somebody asked if the pieces of sperm found in the child's vagina can be used. You said the doctor. Now, the doctor's statement serve as the third or witness or second or a witness towards the act? That's
Yes,
doctor's
it
report
can.
now.
You see, the doctor, when the incident took place fresh, because within 24 hours, you must go to a medical expert to examine you and write a report when
Yes,
it's
sir.
fresh. So the medical doctor will say, okay, so person was brought to his facility at so
Okay.
time, and the victim alleged that by so time something happened to her by so person. I've carefully examined her, and I found some semen on her private part and some lacerations, in part of that kind of a thing. And write a
Yes, sir.
report and come and say. So you see, that doctor will also give evidence. And
Okay.
the evidence of the doctor is corroboration. It's a corroboration to the fact that the girl said that XY said defile her.
Okay.
Unlike in case of rape, where in Popola versus State, the requirement of corroboration was jettisoned because there was no medical report tendered, and the cost is, held the accused person guilty of rape, based on confessional statement.
Sir,
Sir,
in the
my
case of defilement,
Sorry,
So I
sir,
have
I
a
was locked
question.
out. I did not hear what you said.
You said?
I was locked out. I asked about corroboration of a child in the case you just mentioned. I didn't get your response. I was locked out.
I said there is a requirement of corroboration in the case of defilement. Unlike the case of rape, where in Popola versus State, the requirement has been jettisoned. So a child is believed to be so young, and that her evidence may be incoherent or inconsistent because of her young age. So it is a legal requirement that there must be a corroboration before an accused person can be convicted for defilement. So somebody asked me whether the sperm found on the child can be a sort of corroboration. I said yes. I said, but it has to proceed from a medical expert that examined the girl after the incident.
Okay. So does that mean that if it takes longer period and they cannot get the semen at that time, maybe the rape happened when the person was 3 and you report at 10? So that means you cannot get justice for that.
It will not fly. It will not fly.
So I have a question.
Yeah.
It said under the criminal law of Lagos State 2011 that sexual intercourse is punishable with life imprisonment. Does this cover defilement too?
Wait. Under the criminal law of Lagos State, Section 258 provides for the offense of rape. It provides for the offense of rape. And I also gave you the instance of sections 259 and 261, which talks about assault involving penetration and assault without penetration. If it involves penetration, it is life imprisonment. And having sexual intercourse with a child below 18, Section 357, Criminal Law of Lagos State, is punishable with life imprisonment.
So, you don't get my question, sir. I'm talking about the last point you made, like sexual intercourse with a child. And then said
I said it's a crime. Sexual intercourse with a child. A child means anybody below the age, any girl below the age of 18.
And sir, under defilement, you mentioned okay. I think I get it, sir.
In Lagos State now, by virtue of Child Rights Act, sexual intercourse with a girl below 18 will amount to defilement. The only thing is that it will not be the type that will attract life imprisonment because it's 13 years and above. So, but it can be a misdemeanor of 2 years.
So I have a question.
Yes.
In the case of defilement, what if the lady is older, she's an adult, and the the guy is a minor. And also this recent case of a man defiling a 16-year-old boy.
Wait. Let's take it one by one. If the victim is an adult and the accused person is a minor, the question is, who is the complainant? If the victim is the complainant, then of course she has no case. Because the accused person lacks legal capacity, depending on his age, to commit sexual offense.
No, sir. The accused is the lady, and she's an adult, while the victim is the guy, and is a minor.
If the accused is a lady, you know definitely that accused person can be prosecuted under assault occasioning penetration.
Okay, sir.
So
in this recent case of a man that defiled a 16-year-old boy, is that rape or defilement?
No, that can pass for rape under VAP Act, because that one is gender neutral.
Okay, sir.
You understand? But it can also pass under the provision of Section 259 of Criminal Law of Lagos State. It's also gender neutral. If it is boy to boy, or if it involves penetration, you know, penetration, a boy can penetrate the anus of another boy.
Yes, sir.
It will not be rape under criminal law of Lagos State, but it can attract life imprisonment under Section 259.
Okay,
But
sir.
Sorry, sir. May I be clarified on this issue? Where you have a friend who has a girl of 16 years, but the girl grew more than her age. And one old man that has a lot of money decided to beg her to give the girl to him to marry. He bought healers, gave her a lot of so she's now forcing the girl to accept the old man for marriage. Can somebody, a friend like us, sue her to court? Will court recognize our suit?
Now,
because
you said the girl is 16 years old.
Yes, only me as a friend and two people knew that the girl is 10, that the girl is even crying.
Wait, definitely that girl is a minor under the current position of the law. Child Rights Act. She's a minor.
Can I sue on her behalf?
No, it's a matter
this is the mother now forcing her to marry old man because of money.
You don't need to sue on her behalf. Just report the case at the police station. You see, we have the wing that takes care of children and gender, women and children. They will take up the matter. They have been prosecuting cases like that.
Okay.
You understand?
Thank you. Yes, sir.
The girl is a minor. But you know cases like that, people, there will be influence and pressure and so on. You know, so, and you said they have money, they will give e-locks to the father of the girl, brand new e-locks car. And the father will say, I'm a Christian, I don't like to drag. God says we should forgive others, let it pass. You know, it happens.
They will even go and update the date of the girl. I mean, upgrade it by going to court and swear and affidavit that the girl is above age. They will do it because of money.
If the pregnancy is still at a very low, young age, they can even decide to terminate it as well. It becomes a private affair. So that's the issue.
Sir, you gave us two requirements, like two things. You mentioned two things, which are like time frame.
The first one is time frame, which must not be more than 2 months. Second one is the requirement of corroboration.
Sir?
The second one is the requirement of corroboration.
The requirement of corroboration, yes. So I want to ask, you know, let's say the issue is coming up way ahead of the 2-month requirement, the time frame. But for the second leg, I mean after the 2 months, I mean, okay, I mean after the 2 months, let's say a year, for instance, or in the case you just
even if it's 3 months, you know, I gave you the case of the case that went on appeal, the case of Mayaki versus State. That was what happened in that case. And on appeal, the court held that having initiated the case more than 2 months after the alleged commission of the act, that the charge of defamation was due.
The question I want to now ask is that even if after, let's say 2 months, let's say 3 months, for instance, there are like pieces of evidence that are still going to like substantiate the commission of that offense, because of this 2 months requirement, will this suit still fail?
The suit will fail for defilement, but it may still pass for another charge.
Okay, then please, sir, I would like you to please help me run through these statutory frameworks that you gave us under this exception to this indecent assault, section 360 of the Criminal Code. You mentioned 2 years, misdemeanor, any person. I just noted them like scattered, but I can't really piece them together. Please, could you please help me run through them?
Exceptions to?
No, the statutory frameworks for indecent assault, where you mentioned 2 years you mentioned 2 years something, then on a girl below a girl under 13 years old in Lagos.
I gave you section 360 of the Criminal Code,
okay,
which provides that any person who unlawfully and indecently assaults a woman or a girl is guilty of a misdemeanor and is liable to imprisonment for 2 years.
Okay.
Then I also told you that section 285, sorry, I also told you that, I'm trying to, okay, I told you that under section 222 of the Criminal Code, consent is graduated in Lagos to below 13 and above 13. So I said, if it is above 13 but below 16, I said if the victim is below 13 years old, it is punishable with 3 years imprisonment. But if above 13 but below 16, it is 2 years imprisonment. That's section 222 Criminal Code.
Above 13 or below 16?
Above 13 but below 16 years.
Okay.
The victim. That's section 222. That's section 222. But section 360 is talking about, is a blanket application, any person who unlawfully initially assaults a woman or a girl, guilty of a misdemeanor and is liable to imprisonment for 2 years. But if it is illegal, it's graduated.
Okay. Okay, thank you, sir.
Good morning, sir. So please, I just have a simple question. Sorry, sir. Are you still taking us bestiality and co? You said this is the last class.
No. Yes, we are not taking those ones.
Okay, thank you, sir.
Those are the relevant ones.
Hello, sir.
Okay. Hello.
Hello. Please, sir, when will our test be?
Your test will be during your 1 week of residency before the exam. You have a week residency before the exam starts. But you don't know. You don't know that you are resuming in the hostel, maybe next week or something thereabout.
Sir, we know. Sir, the test, is it your topic, sir?
No, well, I don't. You want to force words out of my mouth.
No,
But
sir.
obviously, it won't be my topic. I reserve my topic for exam.
Sir, is it Prof. Akim Bello's topic, sir?
No, it will cut across all you have been taught before I started coming to class. All those who have taught you, whether Akim Bello, whether Akitayo, whether Mrs. Epo, whether Bangoshe, all what they have taught you before I started coming to class, to read them for the test.
Okay, sir. Thank you.
All right.
Sorry,
So
sir.
enjoy the
Would
rest
it
of
be
your day.
physical?
Huh? You said?
Would the test be physical?
Yeah, it's going to be physical. That's why I said during your residency, week. It's going to be physical. Nobody will give you CPT for law questions. It's going to be physical. You are going to write. Huh?
Yes, I want to ask that you said that under section 219 of the criminal code, the punishment for the person that defiles a girl would extend to the owner of the premises. I want to ask if there is any qualification for that, but that probably the owner of the premises has to know that such acts took place, or without him knowing,
You
he
should
just
know
extend.
that. You should know that it's a matter of evidence. If they use my premises while I'm not around and I'm not aware, definitely I will have to exculpate myself now. You understand? So it is in cases of those who connive. You understand? If there is evidence that there's connivance or condonation, then the owner of the premises will also be subjected to punishment.
Okay, sir. Thank you, sir.
Or if you are negligent. For example, there was a case in Faculty of Business Admin. There was one Baruwa who was lecturing in DLI. You know DLI, Distance Learning Institute. And he promised a girl an admission, the daughter of his neighbor at Ipaja. So the guy was lecturing in DLI as a part-time lecturer. And he has a friend who was a lecturer in Faculty of Business Management. So he gave the girl appointment to meet him in that lecturer's office, the official allottee of that office. By that time, unfortunately, the guy, because they are friends, gave him a spare key that he can access his office anytime. So by that time, the owner of the office was still at home. He has not come to the office. And this Baruwa guy, who is a part-time lecturer, has already given that girl an appointment to meet her in that office. So the girl got there, so he locked the door and raped the girl. He was prosecuted, but the school set up a panel on that official allottee of the office where that act took place. And I can assure you, despite the fact that he was not a party to it, they still imposed punishment on him. I think he was subjected to loss of rank or something like that. Simply because, since it's the official allottee of the office, he doesn't have, the latitude to give a spare key to a third party. And he must hold himself responsible for whatever negative things happen in that office. So he was punished. He was punished, though he was not a party. He didn't know about it. But the matter that took place in his office, that is the issue.
Okay, sir. Thank you, sir.
You're welcome. Enjoy the rest of your day and best of luck in your forthcoming exams and your CA. See you in second semester by the grace of God. Bye.
Bye, sir.
Bye-bye.
Thank you.
Thank you very much, sir.
Bye-bye. Meeting on Thursday, right?
No, we are
Okay.
finished. So I'm not meeting you again unless maybe any of the lecturers may want to arrange a
We love you,
tutorial
sir.
for you.
Bye-bye, sir.
Bye-bye.
Sir, thank you. We'll miss
Okay.
my
Thank you, sir.
Thank
Bye-bye, sir.
God.
Tutorial class for past question.
Bye, sir. Thank you, sir.